Hey guys, Brooke here for Legal Talk Tuesday. Today I'm solo because I am talking about business law, so it's my week. Thank you guys for joining us. Hope you're having a good week. We have seen kind of an uptick in business owners specifically trying to get some of their legal documents in order, maybe things that they have procrastinated or that they need to revise for whatever reason. And so I really wanted to talk to you guys today and give you three main reasons why drafting your own contract is a bad idea, because more and more I'm seeing people asking for advice or for resources, and oftentimes people just refer them to online, or you can use this or that, but there are different reasons why that's not a great idea. So beware, business owner friends. It may be kind of tempting to save a buck and grab a business form from some kind of random online search, but doing so could really leave your business vulnerable. So first, yes, if you are conducting business, you likely need some sort of contract, probably multiple contracts or agreements within your business, especially if your business is a service-based business. So the first reason it's a bad idea, you may not include all of the necessary provisions in your contract if you are doing it on your own. So piecing together multiple parts of documents found online, that can be dangerous. By doing this, you may leave out important things that need to be included to actually protect your business. And business needs actually vary and industries vary. So that should be reflected in your contracts as well. So, if you are in marketing, your contracts won't look like a contract for legal services. So you can't necessarily always pick up something from a friend and replicate that. So an example would be if you have an independent contractor agreement. A lot of people work with independent contractors. So you have that for insurance agents. Basically, you're always going to need a non-compete and a confidentiality provision. But freelance web designers, for example, likely would not agree to, nor should there be a need really for them to be bound by non-compete or confidentiality provisions in their agreement. So, insurance agents have access to customer lists and confidential business information. And if that's not protected by inclusion in their contract, then the results can be really detrimental to your business. So that's the first thing, that you may not include all necessary provisions. The second reason it's a bad idea to draft your own contracts is that the law varies from state to state, like I mentioned. So you're not necessarily going to be protected. You're not necessarily going to have everything you need if you're doctoring a document from another state. And oftentimes, if you're Googling, you're probably going to come across things from different states. And so there are areas in business law that are consistent across multiple states, but there are a lot of nuances that you wouldn't necessarily know if you didn't do this on a regular basis. And so that's something you want to consider. So, for instance, a non-compete in California may fail to include things that are required for a non-compete here in Arkansas in order for it to be enforceable. So there's an example of this. There's a case actually out of Western Arkansas where a non-compete was considered to be too broad, and that was unenforceable. And so the consequences of that can be great. That can be a big magnitude. It can be very detrimental to your business if you have this non-compete that your business is relying upon and it becomes unenforceable because it is not narrowly tailored, it's too broad, if there's language that's not used because you're basing it on something specifically from another state. So you really want to make sure that you're at least getting some advice on what that looks like if you're drafting your own. And the third thing, you may not understand or necessarily foresee possible consequences, things that could happen. So there are certain things necessary to make the contract legally enforceable. That's one thing. So you have to make sure that you have all of those things in place. You have to make sure they're included. You have to make sure that the execution of the actual document is done correctly. Different documents require different things, whether that is, witnesses, signatures, how you sign, when it takes effect, things like that. You need to make sure that that's done correctly. An attorney is trained specifically to recognize and identify potential issues, not only now that you might be facing, but also in the future. So that's why it's valuable to at least consult someone. So an example would be if you are entering into a business partnership agreement, which happens very frequently. At first things are great, you're excited, it's all love, you're kind of in that honeymoon phase, and you don't want to burden yourself with having hard talks about things that you don't necessarily anticipate happening, to include that in your agreement, or worse, you don't think a contract is even necessary. You do the old handshake and thank you, we're on the same page. But the problem is that business divorce is a real thing, and you have to prepare for the worst. And so you may not even know what that is. You may not be able to even anticipate that, but an attorney can help you anticipate those things, advise you, and help you to kind of navigate that difficult stuff, those conversations with your business partner or partners. And so you don't want to get in a situation where you haven't adequately prepared. And so having those conversations protects everyone. It protects everybody involved. But if you don't necessarily know what could go wrong, you're not going to include those things in your contract, in your partnership agreement, or whatever you're working on. And so it's really important that you are properly advised on those things as well. So 3 reasons that it's a bad idea to draft your own contract, at least without consulting an attorney or having an attorney review it, is that 1, you may not include all of the necessary provisions for your contract. 2, the law varies from state to state, so you may not even have an adequate contract. And 3, you may not understand or foresee possible consequences and things that could occur in the future, and how your contract and drafting your contract affects those things or could prevent things. So thank you for joining me today. Like I said, we see these contracts all the time, and sometimes by that time that it gets to us, that someone's coming to us, there's already a problem, and it's really too late for us to be able to assist with that. So be proactive, protect your business. This is a great time to reevaluate your business contracts, your agreements. If you don't have things, sit down and figure out what it is that you might need. But it's a really good time now to evaluate that. And so here at MVL, we are steadily reviewing, documents that other people have drafted. We don't necessarily turn it away just because somebody else drafted it or you draft it. We, will advise clients on those contracts, or, provide some comments and feedback. We like to do that prior to entering into the contract, but sometimes we get them after. And then, of course, we do the drafting as well. So next week, we will be here at 11:30 a.m. Central for some more Legal Talk Tuesday, and Laura will be back here with me. Hope you guys have a great week, and thanks so much for joining me.